A second mistake that companies make with respect to their patents is filing their patent application too early, filing it before they really have their invention completed. Now, it's not necessary when you file a patent application to have built a prototype or to completely have it built the product that you're trying to patent. But you do need to understand the details of how your invention would be built, how it would work. The example that I like to use is the perpetual motion machine. Now, it might be that you have a concept for a perpetual motion machine, but you're missing a couple pieces. Well, until you get the pieces, until you understand all the various parts for implementing your invention, or could get to the understanding of those parts with a small amount of experimentation, then you really don't have enough yet to file your patent application. An important law case that discusses this point is New Railhead Manufacturing versus Vermeir. In this case, New Railhead had a patent on a technique for horizontal oil drilling. Now, typically when you drill for oil, you have a drill that goes straight down, vertical drilling. But there's some cases in which horizontal drilling becomes valuable. For example, let's say you're drilling next to a lake, or you're drilling next to a building, or you want to get to oil that might not be on your property, that's on your neighbor's property. So you drill down and the drill bit can actually turn and you can drill horizontally. Well, New Railhead had come up with some technology that enabled this. They filed a provisional patent application. They then followed on with a non-provisional application and then ultimately sued a couple of companies for stealing their technology. Now, I'm not exactly sure what happened here, whether the technology was patented before it was actually ready, or whether it was just amateur hour with the provisional patent application. But the provisional patent application did not describe in detail how to actually get the drill bit to drill sideways. There just wasn't enough detail in the application. Now, the inventor on the witness stand said that he understood in his head how to do it, but he just didn't get that information down into the provisional patent application. In its opinion of the case, the court seems skeptical as to whether the inventor really understood the invention at the time that the provisional patent application was filed. But in any event, the patent was held to be invalid for failing to describe sufficiently the details of the invention.